and that it is correct.
Great, thank you. Now let's look to employee rights. What rights do employees have under the law when it comes to their social media activities? Emma?
Sure. So, hi everyone. We'll try not to bore you with a long discussion of the law, but we do want to highlight a few areas that employers do need to be aware of when addressing employees' social media posts to avoid getting into legal liability. So, there's a few areas to keep in mind. They include privacy rights, rights afforded to employees under the National Labor Relations Act, rights under whistleblower and other anti-retaliation laws, First Amendment rights, and other rights that can arise under state and local laws.
So that, you said a mouthful there, right? So you call Emma for good legal advice about that if you can't get a hold of me and Julie. But no, seriously, Emma knows a whole bunch on this area, as you'll find out later. Employee privacy rights. What privacy rights do employees have with respect to their social media posts? Emma?
Sure. So if an employee's posts are public, they likely do not have any privacy rights with respect to what they're writing online. However, if their posts are private and the employer asks them for access to their social media account, asks them for their password, for example, and then views those private posts, it could implicate privacy concerns. And it's important to note that some states have passed laws that prohibit employers from asking for their employee passwords, or from asking them to log into their accounts in the employer's presence, or for asking them to add a company representative as a friend to their social media account.
All right. So National Labor Relations Board, National Labor Relations Act. I touched on this a bit with the people in the morning. I may have slept through it. So this is going to be some good stuff from Emma here. What rights do employees have under the National Labor Relations Act with respect to their social media posts under the NLRA?
So under Section 7 of that act, and it's important to note that that act applies both to unionized as well as non-unionized workforces in this regard. Employees do have the right to engage in concerted protected activity for the purpose of collective bargaining or for the purposes of mutual aid or protection. So again, that's another mouthful. What does that all mean? It basically means that employees can discuss things like their pay and their working conditions, employer decisions and the like with their coworkers or online if they're acting to try to improve those conditions or to try to protect themselves and their coworkers. And those, again, are important rights to keep in mind because oftentimes employees, when they're upset, do go, to Facebook or other social media and complain. And when employers find out about those posts, they're understandably upset and they want to take action. But it is important to pause and take a moment to reflect on all of these different potential employee rights and to consult to avoid getting yourself into a worse situation.
Well, because I think you touched on that, the rights are seem pretty broad. Are there limits to those protections under the NLRA?
Yeah, so luckily for companies, employees can lose the protections under the act if their conduct is so abusive or insubordinate to the point where it's disruptive to the work environment. But where the line is drawn there is a little blurry and it tends to shift depending on the presidential administration. So while companies enjoyed broader rights to take action against employees for making disparaging or insubordinate posts under Trump, it's likely to swing back to a more pro-employee stance under Biden. So we're waiting to see, where things land there.
Okay, well, so what can a company do if an employee posts negative comments on a site such as like Glassdoor? Kristen?
Well, that's a fun one, and it's one that if I haven't had to deal with it yet, you will. We can't make everybody happy, but we try. So I think what's important, if somebody does write something negative, just to be ready, be prepared. Glassdoor gives you a notification. It's about almost 24-hour notification. Hey, this post is going to go live. So when you see that, if you're the one that is maintaining your Glassdoor account, if you see that come into your inbox and oh, this is a negative one, if you need to, talk with your legal counsel, talk with your HR team, talk with your marketing team, structure that response appropriately. Or maybe sometimes you decide you're not going to respond at all and you leave it there. I think definitely during the onset of COVID, and some companies were having to lay employees off. That was very difficult. And some took to Glassdoor to air their grievances. So, sometimes you can't make everybody happy, but keep in mind, if you do post a rebuttal, to that, to the Glassdoor post, they cannot add to it again. So for 365 days, they cannot come back and talk about that. Also, if they are talking about anyone by name, Glassdoor will red flag that, and they will not allow that as well. They will block some of those posts. So that's a good thing about Glassdoor. They do watch that. But I think it's important to make sure you're paying attention to your Glassdoor profile, or you know what people are saying on your behalf on those outlets.
Okay, well, great. And I see that we have a question, but I think what we, ladies, y'all make sure that you are with me. You want to try to take that at the end of some of the stuff that we were going to plan to talk about. Would that work? Okay, but make sure and kick me figuratively and not let me miss that. Okay, so whistleblower laws. What rights do employees have under whistleblower laws with regard to their social media posts? Emma?
Yeah, so what rights they have would depend on, your jurisdiction and what law is at issue, but some of the types of protections that can include are the right to complain about unsafe working conditions or conditions that implicate safety concerns for the public, illegal conduct or fraudulent conduct. So there's a wide variety of things that could potentially pop up that might be protected.
So that talking about, some, whistleblower and retaliation is kind of like a whistleblower is, a First Amendment comes to mind. What First Amendment rights apply to social media posts, Emma?
Yes, so government employees do have certain First Amendment rights to make posts on matters of public concern in their private capacity, provided those rights aren't outweighed by the employer's legitimate interests. So
yeah, the Connick v. Myers big test, right? So I think we have a polling question. Yes. So do First Amendment rights extend to employees of public or private companies? Do we have, so do First Amendment rights extend to employees of public companies, private companies, both, or neither? Let's see what our results are. Dun, dun, dun. Drum roll. Oh, okay. So
yeah, so I guess probably we should have said, do they have First Amendment rights with respect to making comments about their employer? So the answer is generally neither. So First Amendment rights are typically limited to government employees with respect to making comments about their employers. So, we often do hear people, try to assert that they have a First Amendment right to say something about their company, but typically that does not apply.
Yeah, and thank you for making that explanation, because I think, we're also trying to see if everybody was listening, paying attention, right? The kind of tricky thing, because it's public, wait, so thank you for making that distinction, because you're right. I have a First Amendment right to get on Twitter. No, you don't, right? So thank you. Other state and local restrictions, are there any other laws that employers should keep in mind, Emma, when they're evaluating the employee social media posts?
Yeah, so it really depends state by state and sometimes even city by city. Some jurisdictions do extend protections to employees to make certain political statements or have political affiliations. Some jurisdictions have laws protecting lawful off-duty conduct. So again, it's always important to consider all potential applicable legal restrictions if you have a concerning employee online post before taking action.
All righty, thank you. Let's look at social media policies. What should employers include in their social media policies to protect the company? Kristen?
Well, first of all, you should definitely have them. So if you don't, I would encourage you to do that sooner than later. But you definitely don't want your employees, we mentioned before, to disclose any type of personal information, trade secrets, confidential client information. That is a big no-no. But you also want to make sure that they don't violate any of the policies, such as company harassment and discrimination. That's really important as well. And that they're not making posts on behalf of the company. I say firm because we are a firm, but of the company. Make it clear that their posts are their own personal opinion and they're not speaking on behalf of your organization. For as far as the ownership of the company social media accounts, you want to define who has the ability to post on behalf of your organization. And it should be a very small group of people who have been vetted. And then each of their posts should be, yes,
Yeah,
very small.
Yeah.
And then their posts should be vetted. And be sure that your employees are not using their company email address for private social media accounts, and that they're not posting on company time. The great thing that we've seen, a lot of organizations, their IT departments have actually blocked access to posting on social media sites. And I think that does help reduce some of that, especially if they were trying to use a company address. But some employees will go and post from their phones, and you only have so much control. But encouraging them, having that in your policy, what your requirements, your expectations are, very important.
Yes, certainly, because you can certainly look at it from a disciplinary perspective. If it's like, between the hours of 3 and 5, you're engaging in a Facebook fight with someone, and we're paying you, right? So that happens, as y'all both know, right? Okay, so who should be involved in drafting, Kristen? Who should be involved in drafting those social media policies?
Definitely important to have your legal counsel and your HR leadership involved to make sure that all the guidelines are in accordance with your company policies, but also any legal policies that need to be addressed. And make sure that the employees know the expectations, since they're the ones that are posting. And working with your marketing, not the employees, the employees of like the marketing team. So most of the time your marketing team are the ones that are posting. But make sure that they know what those guidelines are and that they've agreed to those if they're going to be ones that are privy to making those posts. And make sure that they know the steps to follow as far as proper tagging. Tagging is really important. You guys have seen that hashtags, they're great for search engine optimization, showing camaraderie with other people you're coordinating with, but you want to make sure that you have their consent and they're okay with being tagged. It's tagged appropriately. So make sure your marketing team or your HR folks, whoever's handling those posts, know what those guidelines are as well. And then last of all, make sure that they know what to do if there is negative post or something that goes rogue, and how to handle that and address it appropriately and timely.
And timely is very important.
Yes.
If something goes viral and your marketing team is out having some margaritas, and I'm sorry I keep talking about alcohol, that's been, ladies, you may not know this, I've been doing it all day, so then you're behind the curve. Okay, so do you recommend any other steps with respect to social media policies, Kristen?
I think it's important to present it to every employee. I would encourage you to do it as part of your new hire orientation. That's what we've chosen to do here at Whitley Penn. We do have that as part of our new hire orientation, and we have a form that they can fill out. And if they don't want to be involved or they don't want us to post anything about them, whether it's positive, for sure positive, if they have a new credential or they've done something great. But if they haven't given us our consent, then we don't post about it. We honor that. So I think presenting that to everybody from the day they walk in the door of your organization is key, so they understand what the expectation is. Include it in your handbooks and your policy manuals and things like that do change over time, but it's there as a point of reference at any time for your employees. And be sure that, again, that somebody in leadership is vetting all of the posts that are being made and that they're responding to any of those comments if need be, and working with HR and legal counsel on any of those that need to be addressed.
All right, well, thank you. Are there any legal restrictions that employers should keep in mind when drafting social media policies, Emma?
Big surprise. Yes, of course, there's lots of things to keep in mind. And this is another hot area for the National Labor Relations Board. And again, this applies to both unionized and non-unionized work environments. And again, we've seen variances on where the board has landed on these topics, depending on who's in the current presidential administration. But there are some takeaways and some different areas to focus on. So the first is social media policies that place any restrictions on talking about pay or other terms and conditions of employment. That's a pretty clear violation of Section 7, depending, doesn't even matter who's in the administration. So those should definitely not be in your social media policies. Similarly, policies that include broad restrictions on posting confidential information just generically can also be found to violate the Act. And that's because the board has taken the position that if you just flatly restrict discussions of confidential information, employees might think that means they can't talk about their pay or their working conditions. So that doesn't mean you can't prohibit employees from talking about truly confidential information online. You just need to make sure your policies are clear. And the best way to do that is to provide examples and definitions. So include, a laundry list of, you are prohibited from posting confidential information such as trade secrets, proprietary information, pricing lists or marketing and business plans, confidential information about customers and clients. So if you have that type of explanation, then it will pass muster. Other areas where companies have gotten into trouble is having social media policies that restrict talking about disparaging or inappropriate comments about the company. And again, here, this is an area where you want to provide examples to try to make sure your policy will pass muster. So again, refer back to other policies that are lawfully included in your handbook or your policy manual. So for example, you could say online comments or posts that contain inappropriate comments that violate the company's harassment policy or discrimination policy or an anti-bullying policy are not permitted. So having, again, those types of definitions and examples will help your policy pass if it is challenged. And another area where companies have gotten into trouble is having a flat prohibition on employees being friends with each other online. So again, the board has sometimes taken the position that that would be unlawful under the act because employees, again, have the right to reach out and have discussions with each other about their terms and conditions of employment, including online. So the takeaway here is that employers should closely review their policies with HR and legal to make sure that they don't have these overly broad types of restrictions that could get them into trouble under the law.
All right. Well, so what are other best practices and or practices in general, Kristen, do you recommend when it comes to social media in the workplace?
Definitely. I mean, what we mentioned before, the consent forms, I think that's first and foremost the best way to start. And then even to go as far as education, maybe do a little bit of a intro from your marketing team to people about social media, how they can share. We do that a lot with our new hires here, and it's just basically letting them know, hey, we're very active on LinkedIn. We would love for you to like and share the thought leadership pieces we're putting out. So maybe teach them a little bit. Going back to tagging, be sure that we have consent on tagging when we're tagging vendors, clients, contacts. Again, it can be a great SEO tool, but it also can be an area of sensitivity. So we want to honor that as well. And then treating issues with employee social media posts consistently, just to be sure you're avoiding any discrimination claims.
All right. Well, we have a few scenarios that we thought, with some polling questions, we thought might be fun for you folks. And then we have 3 questions, but we'll probably do the scenarios first, a couple of them at least, right? So first one, Emma.
Okay.
I think you had one, you wanted to start off with a really good one, so.
Yes. So in one case, after discovering that they as employees owed more state income tax than expected, employees of a bar called Triple Play Bar and Grill posted critical comments about their employer on Facebook. So one employee liked the Facebook status of an initial poster, which had stated, maybe someone should do the owners of Triple Play a favor and buy it from them. They can't even do the tax paperwork correctly. Now I owe money, WTF. Another employee posted, I owe too, such an asshole. So those online posts occurred after a series of discussions that had taken place earlier in the workplace about the employees' concerns about how the tax withholdings had been done. And both employees at issue, after the company found out about the posts, were fired and filed charges with the board and asserted that their terminations were unlawful.
Okay, we have a polling question for everyone. Were these terminations lawful or unlawful? More like Jeopardy, like jumping up and down.
You want me to sing the Jeopardy song?
Yes, yes. If you can sing, I can't. Okay. 37% said it was lawful and 63% unlawful. So Emma?
So in this case, the board did hold that the terminations were unlawful and found that the purpose of the post was to seek and provide mutual support looking toward group action to encourage the employer to address problems in the terms and conditions of their employment. And here, the board found that the comments were not so disloyal or defamatory or disparaging as to lose protection under the act. And there was a couple key things that they pointed to in that decision. So first, they focused on the fact that the posts were on a personal Facebook account. They were not posted on the company Facebook account. And also, here the discussion clearly related to the existence of an ongoing dispute that had been going on about the employer's tax withholding practices, and that was clear from the posts the board found. So that's where they landed on that case.
And it appeared to be kind of maybe a continuing discussion from the workplace, continued, outside the workplace, but relating to a previous discussion. Okay, great. Kristen, did you have an example for us?
Yes. In another case, a bartender at JT's Porch Saloon engaged in public conversation with his stepsister on Facebook, complaining about his employer's tipping policy and the business's customers. After being terminated, he filed a charge with the NLRB. So now we have a polling question about, was this termination lawful or unlawful? Let's see what you guys think. I feel like we need a drum roll or something.
Oh, wow, this one's a lot closer.
This one was a lot closer. Okay, well, the board found the termination lawful because the Facebook posts were not directed at any coworkers and no coworkers responded on Facebook to the posts. That's an interesting one.
That is interesting. It's kind of like the employee's like, well, maybe I should have done that in a, I don't know, text, right? If you're going to complain about your employer, but okay. So Emma, could you provide another scenario?
Yes, and this one does not involve a bar, so we're moving into another area. So in this case, the employee criticized his employer. It happened to be a BMW dealership on Facebook for providing low quality food and drinks at a sales event. And he even included pictures of the event. And the employee was upset apparently that they had hot dogs and other cheap items served at the event. And he thought that that made it less likely that he would have increased sales opportunities arising from the event. He didn't tag anyone else, and no other employees at the time responded to the post. And when his employer found out about the post, of course, he was terminated and filed the charge with the board.
All right, polling question. Termination, was it lawful or unlawful?
I don't know if you can hear the Jeopardy music, but I do have it going.
Yeah. All right. So Emma, what's the answer?
So in this case, despite the fact that other employees hadn't jumped in and responded, the board found the termination unlawful and had found out that the discussion or the post was rather an outgrowth of an earlier discussion. I guess the employees had been complaining amongst themselves about the tacky food before the end of the day as well. The board also noted that the employees' Facebook posts involved the topic directly related to the sales staff's commissions and livelihoods, and therefore constituted concerted activity aimed at mutual protection. So again.
Well, we have got a lot of time, so that's, but we can do, let's just go ahead and, y'all want to do a couple, what do y'all think? Y'all want to do a few more scenarios or get to the questions? What do y'all think? Let's just
answer some questions and do some more stuff.
Okay, so first question, I see that we got at 321, says, what is the standard for determining if an employee is speaking negatively about the company in order to cause financial harm to the business versus just lawfully complaining?
Yeah, so there it would typically depend on what they're saying and the topic they're talking about and whether other employees are involved or whether the topic is on behalf of other employees. So again, if it relates to a wage issue or an employer policy or an employer decision, and they're complaining not just about themselves and not only about, a decision that only impacted themselves, but rather something that impacts, a broader group, it can be protected under the National Labor Relations Act. So that's, one of the areas that you would want to look to. What is the topic of the post? How did they say it? Did they, make such disparaging comments or use such profanity, for example, that it takes them outside the protection of the act? Or is it more within the realm of some of the posts that we've seen here that were found unlawful, where the terminations were unlawful?
And Kristen, what about, the part of this question that talks about in order to cause financial harm to the business? I mean, they're also, they could be violating our social media policies, right? About, causing harm, but I don't know. I mean,
Well,
what are
I
your
think
thoughts about that?
bad PR is always a bad thing. So, I definitely think it could be violating your social media policy. Again, it's really important to have all that in writing and detail what you can. But just the harm to your reputation, sometimes you can't even put a dollar amount on that because depending on what is said or disclosed, it could really crush your organization. So that definitely financial harm could come as a result.
And, I was just thinking though about, thinking about all of it, listening to you ladies, they're damaging the company. They could be as well, but then you got the overriding protection of the NLRA, right? That Emma was talking about, they're damaging the company and it may fall outside the protection of the National Labor Relations Act, but you would have to harmonize your policies with the National Labor Relations Act concerns. So it's the favorite lawyer answer, right, ladies? It depends. Yeah, that's the favorite one that everybody hates on the other end of us. Okay, the next question from Stella Fair, and I think this came in around the time that Kristen was talking about who should be involved in your social media postings, and asked, shouldn't it also involve the IT people as well?
I think it definitely can. It probably depends on your organization and who is involved. For some smaller organizations, they may not have a dedicated marketing individual, or that may be their IT team that helps with some of that. I think always having a good relationship with your IT team is important. I work very closely with our IT team. They were not as involved when we created our social media policy, but as we have grown as an organization, we have modified things like blocking the social media posting during the day from your company laptop. So we've worked very closely together on things like that. So I guess it depends on the IT's involvement with all of those things, but definitely with your HR team, your legal team, and anything that needs to be blocked from an IT standpoint to have them involved.
All right, well, thank you. Emma, did you have anything to add?
No, I agree. I think, it's always good to get all your different constituencies involved. There's, other security angles that IT can, provide insight into. So I think that's important to get them involved as well.
All right, well, we've got a next question. It relates that it's two-part. Can an employer look at a staff member's personal profile, for example, Facebook, and ask them to change your profile picture or other pictures because it does not properly represent the company, even if there is nothing stated or showing in the picture regarding the company?
That's not one I've seen before. I think
I'm just laughing because it's like, how do you even broach that conversation?
Yeah,
no.
I would probably steer clear of that. But I think, a better angle to take is to have in your policy, you can't use your company email account to set up your social media password, just so it's, more separate, their personal from their professional.
One thing there, I would say, maybe, especially like LinkedIn, most organizations use LinkedIn. So if they don't have a proper picture, maybe encourage them or help them with a headshot. And it doesn't have to be go hire a great photographer. You could do, most of us, our phones take great pictures. You could even do that and help them out just by offering, hey, I'm available to help take headshots for anybody who wants the new LinkedIn picture or something.
Well, exactly, because it depends on the social media, thing. Sorry, use my words. Yeah, the social media platform, but because some of them are more professional in general, and it could be a reflection on your company. LinkedIn definitely wants to know like where you're working and whatnot. And it also depends if part of your identity is where you work. Because when I've advised public sector employers, if they have private, they have their private Facebook, but they say where they work, and they're sitting there posting things about horribly offensive things, and with their with a really bad pic that although it's a personal Facebook, but it's still reflecting on the company or on the employer. I think that's a different concern too, that should be in your social media policy, right? So as Kristen would say. So the next question is, did I understand that if you work for a public entity, you do not have privacy rights?
No, so a governmental public entity, you would have First Amendment privacy rights. It's the private companies, whether they're publicly traded or not, where you don't have those same First Amendment privacy rights to post about your company.
And if we didn't answer that, follow back. Kristen, did you want to add on anything to that?
No, I think that's great.
Okay. Next question is, what if the employee's profile information doesn't identify their employer? They don't specifically reference the employee in their post. Okay, they don't specifically reference the employee in the post and hasn't identified their employer in earlier posts, and doesn't reference the employer in the post and hasn't identified the employer in posts, I guess, regarding social media. Do y'all understand the question?
I'm just reading back over it because I don't. So.
I'm sure I've bungled it quite a bit.
So yeah, I think if they're not referencing the employer and they're making a post or a comment that you don't like as the company representative, that would make it even harder to take disciplinary action against them. But again, it would depend on what they're saying and who they're speaking on behalf of.
Exactly, and if it's completely in their whole private, and they're complete in their private capacity, you're right, it may not be disciplinary at all. It may simply, and it also would matter. Remember, folks, if you work for a public sector, not public entity, but a public sector, local government or a state government, the National Labor Relations Act doesn't apply to you, so you don't have to worry about that. You got other things you have to worry about too, but just keep that distinction in mind. Okay, next question. Can you please address political posts and provide some guidance there?
Yeah, so again, it would depend on who they're working for and what they're saying and how they're saying it. If they're, raising a political topic in order to take action to improve their working conditions or something like that, it would be a different scenario. If they're just stating something that's, considered hateful, but is their own personal belief, again, you would see, are they, working for a governmental entity? Yes or no. Do they have First Amendment rights? Yes or no. So there's a lot of considerations that you would have to take into account.
Kristen, did you want to?
I would just say, as far as the people who are posting on behalf of your organization, I would advise them to steer clear of that as much as possible. It is very polarizing. So you're going to make somebody upset. So that would just be my advice.
And the only thing I wanted to possibly add is just kind of tying into what I'd mentioned about the acting general counsel of the NLRB, was discussing, they're broadening what they consider to be, mutual protection, what's protected, concerted. And so sometimes social activism, he's, casting a broad net. Now that's one guy, and he didn't even have the majority yet in the NLRB, but to the extent that overlays it, that's something to keep in mind, keep your eyes peeled in the future. So, all right. Is it all right to share posts from your employer as an individual. As in, yeah, like, and I guess I'm understanding this is maybe branding or helping get the message out for the employer.
That's the way I'm reading it. And if so, then yes. So for example, like LinkedIn, we post thought leadership pieces all the time. Positions we're trying to fill, like come work with us. And I think it's great. I think it's great for people to push that out to their network. And they are showing up, hey, I like where I'm working. It's an extension of the brand. So and in those instances, I think it's fine. Emma, do you think the same or?
Yeah, unless the company had some sort of policy prohibiting it, I would think it would typically be fine.
All right, and can an employer require that volunteers within your organization sign similar policies as employees, presumably social media policies?
Yes, I think that's a good idea. I usually like to have, different policies, employees versus non-employees, just to not blur the lines there. But I think it is a good idea to have, similar type guidance given to your volunteers, particularly if they're going to be involved in any way in your social media posting on behalf of the entity.
All right. Kristen?
Yeah, I agree as well, because they are representing your brand. Even in volunteering, they're part of your group. So I agree.
All right. Well, I think we've gone through our questions, and I don't see any in the chat.
There's
So
one more in the chat, actually, from Dan. What about employees identifying themselves as an employee of a company and then have objectionable pictures or comments on Facebook?
So yes, again, I think it would depend on, what the offensive comment was. If the subject again is, working conditions, pay, policies, employer decisions, complaining that their supervisor, disciplined them, for example. If it's just an individual concern as opposed to one that affects, a larger group, you'd have more grounds to take action. But if they're speaking on behalf of a larger group or in order to effect a change that will impact not just themselves, but others as well, that's where they might have the protection under the National Labor Relations Act.
all right. Well, I'm like, yeah. Kristen, did you have anything else that you wanted to weigh in on that?
No, that's exactly right.
Yeah, that's what I mean. That's like, yeah. So we are remarkable informed, right? So yeah. So let me see. No more questions. Okay. So so Emma, what should the participants take away from all of this?
Yeah, so I think, looking or thinking back to the examples we walked through with the polling questions, the employers did face varying degrees of success in those cases. And it remains a little bit to be seen where the current board lands. But we do always, caution companies to take a step and take a pause before disciplining employees for their online activities to make sure they're not running afoul of any of these different restrictions we talked about today. And even in the cases where the companies ultimately won, they did incur significant legal expense in doing so. So again, this all points back to take your time, make sure that you're, proceeding appropriately before you're disciplining your folks for doing something online that you don't like. And then similarly, as we discussed earlier, take a close look at your social media policies, make sure they have all the right protections for the company, but make sure they're also not overly broad in a way that could get your company into trouble.
Well, exactly. And like, yeah, I think that one of the best advice bits are in there when you said, take your time. Don't fire. And this goes to everybody, right? Don't fire when you're mad.
Yeah.
How many times does a boss come in with their head spinning around like the exorcist and, I want them fired now, because you don't make good decisions when you're mad, and the social media posts look a lot less inflaming through the cold light in a court deposition. So, always remember that if to the extent you're owners of your companies and the other people listen to y'all, that's always another caveat, right? But, fire slow. What are the takeaways from the marketing and business perspective, Kristen?
Social media is here to stay. So I think it's an important tool for business. We've seen that more from just LinkedIn to, you've seen lots more companies that have Facebook, they're on Twitter, Instagram, Pinterest. I mean, any type of social channel is getting a lot more activity on the business world. So I think it's important. It's an important tool for us to have and to use, but it's also important to designate those appropriate spokespersons on behalf of your firm that can create those posts and make those posts respond to any negative posts or questions that may arise from that. And then it's just important to have those consents in place for your employees, your customers, and for anybody you're tagging, just to cover yourself.
Well, I have a question real quick for you, Kristen, that just came up the other day with a situation I encountered. An employee left because they were mad, right? I mean, they were on leave, whatever, but they were also this employer's social media point of contact. And the employee is not returning any of the login credentials or any of the ability to get a hold of those social media accounts. So they're working through those problems, all ears on how to work through those problems. But to forestall that in the future, Kristen, what would you recommend to take employers to take precautions on that?
Well, a couple of different things. That's where it's really important that not one person controls it all. Gotcha. It's very hard, especially with Facebook, if somebody, or even Instagram, and they're tied together now. So if someone were to leave and they have the login credentials and you're trying to change it, Facebook will go back to the original person. And if that email address was tied to when it's no longer at your organization, it's not active, it is a mess trying to get it fixed. So when we talk about that small group of people who have access to post on behalf of your organization, you also need that small group of people who know the passwords and are an admin on your social channels. And when something is going south with an employee, or it happens immediately, your other person needs to change those passwords, or maybe even before. If you see something starting to change, take away those rights and go ahead and change those passwords, because it's really hard to work backwards once they've left your organization, and those channels are kind of on lockdown.
Well, thank you. Yeah, I didn't know if that happened with anybody else, but it happened with someone I was talking with, and I was like, wait a minute, I got the experts right here, so I'm going to throw that question out if we had time. So great. Well, thanks, y'all. I don't see any other questions. I just wanted to thank both of y'all for laying all this awesome knowledge in with these attendees. Thank you for your time and your intelligence and articulation. So thank you so much, ladies.
Thank you for having us.
Thank you so much.
Yes, thank you.
Applause, silent applause.
Oh yeah, I can make noise. Yay.
We are gonna go ahead. It's 4 o'clock, so we're gonna go ahead and do our raffle draw. So just a little kind of quick update on
doing the raffle before the question and answer. We're gonna let them get away with the raffle without hanging out for the question and answer. I mean, I was just asking Joni. We could do the raffle. Okay, we'll do the raffle.
Julia, they'll hang around because I'm now on the round table. They'll hang around for me.
Well, no, we've been enjoying your comments all day, Coffee. What do you mean? Okay, so do the raffle. Okay.
Yeah, so these were pre-drawn. We did this, don't worry, there's integrity. We did this through Excel. It's all randomly selected. So I'm gonna go ahead and
sorry, Joni, I was doing the wink. No, she's being serious. It was randomly selected. Oh, look at Mike. Okay. Go ahead, Joni. She's going to regret ever asking me to help her. I know that's what the silent thought cloud is in her head.
All right. So as you remember, Sana came on, and one of their first prizes is a Sana branded Yeti road cooler, which is awesome. If you're going on a vacation or a camping trip, this is going to be a great addition. So the winner goes to Haley Archer. If you are, feel free to type a chat message, but congratulations. We are
Archer Trophy Club. Are you going to share with your Don't do that. We won't tell anybody else there. Congratulations, Haley.
Yeah, and by the way, to get these, we will contact you after the conference, probably sometime next week, and we'll find a way to get these gifts over to you. So congratulations, Haley. Yay!
Yay!
Okay, next one here is $100 Southwest Airlines gift card, which is pretty awesome. I know traveling's a little interesting right now, but I'm sure we're all dying to travel around the world. So the winner for this is drum roll.
Drum roll.
Bonita Hall. Yay, congratulations.
Congratulations, Bonita.
Again, we'll send that over to you afterwards.
Sherry, yay, Bonita.
Yay. Third prize here is $100 Marriott gift card. And the winner for that is Ryan Bailey. Congratulations, Ryan. Hope you're on as well. Make good use of a Marriott stay. All right, and then our fourth prize here is from Gus Bates, and is a $100 gift card for Cadillac Wines. I know Julia's been talking about drinking since 8:30 this morning, so she's
Oh, yes, it's 8:25 actually.
It's hard.
So, yeah, you're saying.
and the winner of this gift card is Christopher Crow.
All right, congratulations.
Congratulations, Christopher. A lot of wine for you.
That's awesome. Oh man, I want this one. Oh wait,
Yes.
okay, Julie Ross again, right?
All right, so this one's from our favorite Mike Coffee here from Imperative. This is a $100 Joe T. Garcia's gift card. And the winner is, no, Mike cannot win his own gift. That is correct. The winner is Glenna Standish. Congratulations, Glenna. You'll have tons of margaritas and delicious foods. Yay, Glenna.
Yeah, I'm echoing.
Glenna,
Glenna's
we're
question.
overdue for lunch anyway.
Yeah.
just
Just
saying.
saying, Glenna, right? Yeah, I was gonna say I'm with Lily. Chris has got to share his wine. So all right.
Awesome. Well, congratulations to all the winners. We made it. I know we do have a lot of Q&A coming up, but we're just going to close here real quick. Thank you so much, everybody, for joining us and for the 22nd annual employment law update. A huge thank you to all of our sponsors, all of our speakers for making this happen. There's a lot of folks on the back end who are making this seamless and awesome. So huge thanks to those guys as well. Of course, thank you to all of you for attending. We would not be here if you were not here. So thank you.
Very much appreciate your time.
Yes. So just kind of a couple things. We will be sending you a post-conference survey that's going to come to your inbox tomorrow at 9 a.m. After you complete it, you will receive your program IDs for your recertification credit. So be on the lookout for that. If you don't receive a survey for whatever reason, just please feel free to reach out to us at info@fwhr.org. And then a lot of you have also been asking about the presentations, and you will be receiving a copy. I was not anticipating the demand, so I apologize for that. I'm going to reach out to all the speakers and see if they're all comfortable with this. And if so, we will make sure to email those copies over to you sometime next week. So anyways, as I said, this is the end of all the sessions, but we are going to be hosting a short live Q&A here until 4:30. Probably going to go over some of the questions that we didn't get to answer and any new questions. You're welcome to stay for that. But if you are ready to start your weekend, thank you so much for joining us, and we will see you soon.
Get the weekend going.
Yeah.
Oh yeah, Mike's ready. Mike's ready.
That is so not fair, dude. So not fair. Oh man, you got Grogu back there. That's too cool. Okay. Yeah.
All right. So some questions. Let me pull this up. And guys, feel free to answer or ask questions in the Q&A if you are hanging around. Okay, so there were some general questions from this morning. Let's see here. If an employee is out on workers' comp, you are required to extend to them FMLA. Are you also required to extend STD or short-term disability and long-term disability?
Okay, well, if they're on workers' comp, yes, you have to do FMLA leave. short-term disability and long-term disability are not mandatory, unlike FMLA, right? So those are ways of paying employees when they are unable to work. So employers aren't required to provide short-term disability or long-term disability just under the general employment laws. I may not be answering the question right. Mike, Joni, anything else to add on that one?
Yeah, that's too close to having numbers attached to it, and I don't do anything with numbers attached to it.
All right, next question.
All right, next one. Would barring RTW violate the Constitution's freedom of association rights?
And RTW, I'm return to work is what I'm interpreting that as. John Hagan. He asked the question. My thought was, well, it depends if it's a private or a public sector employer, right? If it's a public sector, there's no freedom of association or First Amendment right in the private sector. Public sector, it's a public sector employee. It's an employee. And if you have policy or safety requirements that would prohibit or restrict their coming into your workplace, I think it does not violate the Constitution, because you're responding, you're barring their return to work because of a direct threat issue or other safety concern. Not every person gets to come into a public office however they wish. So I think, if you apply those policies, across the board, and that's the reason, then I don't think, I think that would be constitutional. Mike?
She said. I'm gonna be real helpful this session, I can tell.
We do have a lot of COVID questions that we were not able to get to. So let's see if we can run through some of these.
And Julie Ross, before she had to leave, she helped me out too. So
Yes.
I've got Julie Ross's knowledge and Mike Coffee doesn't. Okay.
What would the liability be if an employee gets really sick or suffers severe complication after requiring the vaccination of your employees?
Well, we're not exactly sure here. It's emergency use authorization for this, and plaintiffs' lawyers can be real creative about ways to sue. They're likely working on that as we speak. Workers' comp, if we're mandating the vaccination, would likely be step in and cover that. And actually the employer would love that if workers' comp came in, because that's an exclusive remedy, right? Workers' comp, you're barred by any other recovery. So if the state or federal legislatures pass COVID shield laws, that will protect as well. And then, when you think about allowing them to, or mandating that they get vaccinated, you always have to think, what's the liability or potential liability for allowing unvaccinated employees into a work site? And then the employee sues for not maintaining a safe workplace, for example, OSHA, or files a complaint with OSHA or something like that. So
Yeah, and I have had this conversation with clients, and I just saw today, by the way, University of California system and the California State College system, or whatever that's called, both are mandating vaccinations this fall for all staff, students, and faculty. And so from a liability point of view, if somebody is that one, and that tiny minuscule number of people who have really, really adverse responses to the vaccine, I think the courts are probably going to say, look at the broad scope of everybody requiring this, and CDC recommending, and all of this. That's going to give employers a fair amount of cover, and certainly just doing the right thing. I mean, I'm not saying that an employer should make that policy or shouldn't, but when you think about balancing protecting our workforce, especially if you've got employees who can't be socially distanced because of the nature of their work, manufacturing or things like that, where they're working alongside each other, protecting the workforce and making sure that you've done as much as you can under OSHA, but just under the general care for your employees, versus worrying about that one instance where something may go wrong. But like Julie said this morning, I think the you also have the ADA considerations, and you need to make sure that pregnant women and anybody else who, basically, alerts that they've got some issue, that you go through the ADA process to make sure that you treat them equitably as well.
You were able to answer a question. You did it.
Yeah, well, it may not be right, but
TX, he's gonna get smarter, aren't you?
well, it goes back. You remember The Office and Dwight Schrute, and I'm going to paraphrase him. When it comes to an HR question, I ask myself, would Mike Coffey do this? And if it's something Mike Coffey would do, I do not do that thing. And so that's my caveat for all of this.
Huge Office fan, so nice reference.
Yeah.
Next.
This question actually comes from one of our own board members, Natasha Paul. What if we aren't going to mandate vaccinations? Should we have a policy written out for that?
Well, you may want to have one anyway, because you're going to have the vaccinated and the unvaccinated. So, if employees are not required to be vaccinated, but unvaccinated employees could continue to be required. There we go. Use my words. And I haven't even had any TX yet. I haven't any of that yummy stuff yet. They could be required to continue to wear masks and take other safety measures to mitigate the spread if they are opting not to have the vaccine. So that could be a consequence of a choice.
And short of having a policy, I really think everybody should have that conversation, whatever their policy, whether they decide to have one, require it or not. They ought to have that conversation with their employees. There's still a lot of uncertainty out there, and I'm talking to a lot of employers who feel the need to bring their employees back to the office for camaraderie purposes and team building and all of that stuff, build the culture, but it's making a lot of people nervous, and there's still a lot of people for whom who don't see COVID as ending right now. They for one reason or another, and so I think just having frank conversation about how we came to the decisions we've come to, and what what we're doing now, and how that may change in the future depending on what the circumstances are, and we're making the commitment to stay in front of employees about it is really important, just from a morale point of view, and to give people a little peace of mind that somebody in management's actually thinking about this stuff. I think that goes a long way.
Oh, we actually have a live question from Megan. Is there any action that an employer needs to take when an employee marks that they have a disability on their new hire paperwork, but refuses to release information about the disability or the need for an accommodation?
Well, first of all, I'd like to make an objection because there's no Rodney here to answer it, right? I mean, I'm just saying that's a Rodney question, and he would bring humor and insight into it. But I'll do my very best, being, Rodney's backup. I would think that, remember what Rodney was talking about as far as when someone says on their new hire paperwork, so presumably they're hired, right? So they've passed if they've been.
But I think this was on the application, right?
Well, the earlier question was application, I think, during it, but Megan is stumping us here, right? Coffee, because it says on their new hire paperwork. So they were hired, they've passed, they disclosed they've got a disability, and it's post offer if unless if they're new hired, they're already hired. So then it's going to come to post offer, post employee. So then you've got to figure out if they say they have a disability, but you either say, we have disability, but we don't want to talk about it. Okay, as long as it doesn't, affect your ability to perform the essential functions of the job, we don't need to know about it either, right?
And I think if they said, hey, that'd be a giant red flag for me, though.
Yeah, I know.
If they said, I've got a disability, but I'm not going to tell you what it is. I think
kleptomania. What?
Yeah,
right?
Yeah, right. Alcohol. There we go. Tell them, hey, go start a background check company. That's, but I think Julia, correct me, but I think in that case, just as a CYA measure, I'd start the ADA process and have them have a doc fill out the ADA paper, send them the essential functions of the job and have a doc certify that, if you don't want to share this with me, I understand, that's fine. But at the very least, I need you, now that you've told me you felt a reason to tell me this for some reason, and you're not giving me additional details. What about just sending them and sending them to the doc and having them do the ADA paperwork? So at the very least, the doc can say, yeah, that this person can do the essential duties.
Well, but the person's just been hired, so presumably they've already passed the medical, right? The post offer pre-hire, right?
Well, but it's like, but any employee, I would think any employee who comes forward and says, I've got an issue. If they're self-disclosing an issue, you don't have to tell me what it is, but I don't know.
Well, and I think it would depend on all of those factors. I think that's a good strategy. Another option could also be is that you said you got a disability. You won't tell me what it is. You felt the need to disclose that you had one. Here's the essential functions of your job, and you're not seeking an accommodation. And so are you, sign that you've received the essential functions of this job and that you can perform the essential functions of the job. And I don't need to know anything else. If it becomes an issue, you're going to have to circle around, but you know what I mean? Because that's you almost feel like it's a setup situation, right? Like,
that's what I'm saying.
I've got it, but I'm not going to tell you. It's like, so, yeah.
With consideration of ADA, again, Rodney's not here to answer this. Now that we have our office staff working remotely for over a year, could it be argued that on-site attendance is not an essential function of their job if they are deemed a quid?
Well, they think, and that is an assertion we expect to see quite a bit. It will certainly be made an assertion, but the EEOC has already stated just because we've done it during the pandemic doesn't mean that they're entitled to it forever, and that on-site, regular, reliable, in-person on-site attendance is not an essential job function. And you would need to analyze it on a case-by-case basis. But I don't think, because I'm dealing with that right now with several clients when they've got employees that are like, I just feel more comfortable at home. And it's like, well, we know that you may, but we need you back here. And so we are gently working towards those issues, but we're keeping the stand because a lot of the ones I'm talking about are public sector folks. And, public sector, if they don't see a parking lot full of people and people in an office at City Hall, they're thinking they're not working. So that's a big push to get people back to work. So.
When I see people at City Hall, I still assume that they're not working.
Oh. Kat Schluter, Rachel Hewitt.
I love all my cities, city clients.
Bonita, come on, someone. Yeah, exactly. Let him chew on his shoes. Anything else you got to say about that one, Mike?
No.
Yeah, look, everybody's ouch, Mike.
The comments.
Not cool. Sherry.
Fired. That hurt.
Oh, he's burning it up. Oh,
would
Tim,
Mike Coffee do this
everybody.
thing? If so, do not do this thing.
Yeah.
This question is actually from Mike himself. If I were good at impersonations, I would impersonate him, but I'm not. So if a remote
Just
working
give a little
employee,
Kermit the Frog voice and you got it made.
not even going to try. A remote working employee has moved to another state. Does that mean the employer now has to register their corporation in that state, get set up as an employer for UI and tax withholding in that state, and follow the rest of that state's employment laws?
And that was just me asking the question to nudge somebody to answer it. And because I've had several clients who called me and said, during the, when we were all in quarantine, we had an employee move to Colorado or several to Oklahoma. What do we do? And I'm like, well, you're an employer in Oklahoma now, if that's where you're going to let them continue to live and stuff. And you got to go check with every state's going to be different. Tax wise, some of those states have state income taxes and you've got withholding responsibilities. And if you're doing payroll in house with, and it's largely an administrative function and you're not using Paycom or any of those guys to manage all those, multi-state stuff, you either have to do that stuff or tell them to come home. We told our employees when we decided we weren't going back to the office that they could live anywhere in Texas as long as they were able to be in Fort Worth for a meeting in 24-hour notice. And of course, I'll give them more notice than that. The only time we do it is going to be probably once COVID's cleared out, a monthly team building. So we, lay eyes on each other, but they've got to do it and they've got to do it at their own expense. They got to do the travel. So if they move to El Paso, well, that's almost halfway across the country. So, that's on them to get back here. So.
And Julie Ross concurs, because before she had to leave, she wrote me a note. Yes, most likely. So it must be correct if Julie Ross says so.
There you go.
Rodney said Julie is wrong, right? Shouldn't he say?
Yeah,
He said he was wrong,
and Beth
right?
dropped in the
Oh my
comments or require they move back to Texas, and I think that's perfectly good too.
Yeah.
Saying, hey, we're not going to become a California. Gosh, imagine somebody moved to San Diego.
I know,
Become
right?
California.
You can live
freaking
anywhere but
employee.
California or New York.
Yeah, New York. Yeah.
I can't believe Emma is like licensed in New York and California. I'm like, oh my gosh, I'm not worthy. Can you imagine learning those employment laws? Whew,
Oh,
okay.
I know, but it's full employment for.
That's true. Well, yeah, I mean, wait a minute. What am I, stupid? Yeah, that's like cha-ching, right? Okay, Joni, next question.
I think she had like 4 or 5 states that
Oh,
she
yeah. Oh, a ton more too, like, and Illinois.
Crazy.
And yeah, I mean, I'm just throwing out the stump and the chump states, I'm like,
Yeah.
oh.
crazy. If in the future we decide to hold a company meeting of all of our managers, can we require that they have had the COVID vaccine before they are allowed to come to this meeting in person?
And yes, under the ADA that you may, but be prepared to consider requests for accommodations under disability and religion. And if they elect to attend, an accommodation could be masks and social distancing. You'd have to do a direct threat analysis as well. Will the unvaccinated employee expose others at the work site? There could be variants. It's a lot of moving parts in that.
It seems like safety tends to trump civil rights from an employment law perspective. So a religious accommodation would be secondary to a health and safety concerns typically. Is that correct?
Well, typically, but remember it's the public policy right now during the pandemic. Individual rights may be subordinate or secondary to the health and well-being of everybody else. But see, also, as the pandemic concerns seem to wind down, and depending on which state you live in, Florida, Texas, it's
Pew,
Texas. So I think that in other states, it takes more of a foremost role than it does in Texas, because we know that Texas has been one of those states that have, anyway. I wasn't going to talk about politics, and I'm not talking about politics. So I think the question, not politically, is it depends on the circumstance. But yeah.
And the other thing is that we have seen that the courts where, at least from a public policy point of view, where the courts have said you can't just target churches. I mean, if you're
Yes.
allowing, groups to get together in other circumstances, and similar thing, you can't just say you can't, that
You
churches
can't go to
have to go
church.
that way. Right.
You have to allow church, even probably more than the other groups.
And so
So,
depending on the facts of a case in the employer section, you could face something similar to that.
and depending on the new emphasis with religious rights that, in the shadow docket for the Supreme Court that we're seeing on Twitter and referenced everywhere. So that's a good thought. So anyway, sorry, next question.
Good question. I think this is related to COVID here. Yeah. Can the CDC enforce any of the employer guidance? No, right? It's just guidance. But following it probably takes some liability off of employers because they can say they followed CDC guidelines. What I'm trying to ask is, how is it discriminatory to say that it's not a reasonable accommodations to put other people at increased risk of death? Want me to repeat the question?
I have it printed out. I'm just trying to, I mean, I don't know that I understand the question. It's, if we follow the CDC, if employers follow the CDC guideline, we've got cover. That's a reasonable objective standard. So if we're following the objective standard, we're not discriminating against a particular person because of anything else. We're trying to be keeping the workplace safe as a whole. So, but I don't know that I answered that question. So,
Well, it's from someone anonymous, so unfortunately I can't specify who it was. Okay, let's see here. So CDC has two paths of recommendations for vaccinated versus not vaccinated. Can we, as the employer, have two policies in place for those who have been vaccinated and those who have not? So, for example, quarantine requirements for exposure, international travel, etc. If okay, can we ask for proof of vaccine?
well, it's probably going to be okay to have two paths under federal law. It's also going to be okay probably under federal law about the traveling. Proof of vaccine before you come back for international law, because it's, you know, all kinds of issues related to there. But remember that state law, if it's more specific and isn't preempted by federal law, and in this regard, that Texas law, several bills that are in the legislature about prohibiting employers from discriminating against employees who don't want the vaccine. So you're going to have to look for state law, you know, BOLO for the state law, what the state legislature is going to do.
Okay.
Mike, anything else?
No, there's a lot of bills in the legislature. I mean, there's employer liability protection stuff that's in there, and then at the same time, you know, and if they pass, I bet they pass together, that we give liability protection to employers, but employers can't discriminate based on vaccines. If you know, they'll be tied in there together somehow. But
Yeah,
you know, I know a lot of employers right now still aren't allowing international travel or requiring some quarantine process before somebody returns to work after international travel. The few places that will even accept Americans right now.
yeah.
Awesome. There are two questions here. Julia, I don't think you've seen them yet, but I'm just curious, you know, what your answers are.
That's not fair. No pre-planning. Okay.
Yeah, I'll put you on the spot. When you do a professional reference on a candidate who has an obvious disability, what can and cannot you ask the reference?
Do they do it? I mean, you can. Do they do a good job? Are they here all the time? I mean, same
Right,
questions you'd ask a regular, if they were almost an interview. Attendance, performance, attendance, conduct is what I always stay. I mean, that is, that's my mantra on things when people go, oh, but it's a such and such protected class. Are we talking about performance, attendance, conduct? That's what I would focus on. I would go, how did he do that job with, you know, he's got big old hearing aids. Did he, you know, no. Mike, what do you think?
No, I think that's right. It's just like you wouldn't ask, did he file workers' comp? Did he have any workers' comp claims during the previous, you know, during your previous verification? We do get clients who ask us to do those, you know, ask those kind of questions. That question, and then the other one, was he involved in the union? We get clients who want us to ask that. I'm like, yeah, you don't want us to ask that, and we're not going to do that.
Yeah.
Somebody to follow up and ask, can you ask if the disability affected their job performance?
I would not. First of all, if you're asking the reference, you don't want to elicit information you don't want to have when you make the decision, right? You don't want to know, you don't want to be on record anywhere asking about the disability. You want to ask about the job relatedness things. So I would steer clear of that as well. You know, he's got one leg. So how did he do that job? I mean, no, just, was he able to do that job? Okay, thanks. That's how I would look at it.
All right, we have time for one more question. Let's see here. What about pre-hire questions about ever having been on unemployment? Seems like I saw that somewhere and don't know why it is being used.
Well, have you ever accepted unemployment insurance? I've never seen that question. I think it's kind of a dumb question. But there's no prohibition to asking about it, though, I guess. You might have to be cautious about how you dig down.
There's a Texas statute that protects employers who provide employee references as long as it's 100% true and not malicious. Right. And I would never dispute what John Hagan's saying, but I tell my folks, I'm like, don't give references confirm dates. I know there's a law, but let's avoid even the issue. But oh yeah, about the unemployment question. Sorry, I'm need to quit.
She needs her drink. She needs her drink.
Yeah, I just think that, I don't think I care about periods of unemployment. I know. Thank you, Mike. I wish.
I'll do one for you.
I just care about
You
jobs.
had, Mike. It's looking pretty over there. How much have you had already?
Yeah. It was full while ago.
Yeah, he's probably drinking vodka or tequila because he's all being keto-y. So
That's
but you're
fine.
healthy, as Rodney pointed out. I was rolling. Oh my God, that was hilarious.
So-
Okay.
Well,
What
it
So
else?
is
on the
the-
unemployment
that's-
question, the other part on the unemployment question, I don't think there's a prohibition, but what Julia said, don't give references, and that's always what your employment law attorney is gonna say.
Yeah.
But as on the other side of the coin, when you're calling to get references, and like when we call for our clients to do references, I think you should always document that you asked. Was
Yes,
there ever any reason to question their integrity or honesty? Did they ever act in a threatening or coercive manner? And a series of questions like that. Let the other guy on the previous employer refuse to answer and
Yes.
document that they didn't respond per company policy. That way, when you get in the negligent hiring system down the road where this guy, does something knuckleheaded and now you're dealing with a negligent hiring lawsuit or retention lawsuit, you can say, hey, we asked. And those guys wouldn't tell us. So there's no way we would have known this. He was diverting patient meds or doing whatever he did before they assaulted a customer. We asked, they just refused to tell.
excellent point. Absolutely. Document the heck out of that.
And I'll tell you, we get answers on those questions probably 40% of the time.
Yeah.
And every now and then they throw the employee under the bus. And so they give you something useful. So.
Well, those are all the questions we have. It's a little past 4:30. So remember at the beginning of the conference, I asked how everybody was feeling. So I am going to poll again. How are you feeling now? Do you still need more coffee? Let's see here.
We'll be together next year at the EOU.
I know. No more virtual hugs, real
Probably
hugs.
by strategic mindset, we'll be together.
Yes. Well, we might be. We might be. Let's see here. That was awesome. I'm glad the 10% I am suffering from information overload. I'm a little with you there. And it's Friday. So awesome. Well, thank you, Mike. Thank you, Julia, for staying.
You're welcome. It's my pleasure.
Q&A. Thank you, everybody, for asking your questions. And again, we're so thrilled that we're here and that you're here and that we got to spend this day together. So
Thank you,
Good job,
Joni.
Joni, Isaac,
Oh,
to
thank you.
the whole ELU group. Y'all did super. This is really,
Yes.
really, really one of the best ELUs, I gotta say, with the exception of being together and all the fun stuff that happens there.
The content was
great.
amazing.
It was
Thank you,
executed
Joni.
really well.
yes. Well, awesome. Well, everybody, happy day. Have a lovely weekend and we will see you soon.
Thanks.
Bye.
Have a great
Adios,
one.
muchachos.